Whether a law enforcement officer is hot on the heels or hot on the wheels in pursuit of a suspect, when that suspect enters into a dwelling, may an officer enter into that home without a warrant regardless of the offense? The Fourth Amendment to the Constitution of the United States of America places a prohibition upon the unreasonable searches and seizures by governmental actors. While the amendment itself contemplates the method by which a warrant may be obtained, it does not explicitly require that a warrant be obtained in the event of every search and seizure. The Supreme Court has held that the ultimate touchstone of the Fourth Amendment is reasonableness. In terms of conducting a search of a home, that is to say, entry of a home, the court has identified several exigent circumstances where it might be reasonable to enter a home without a warrant. The court has permitted warrantless entry of a home to preserve human life, prevent the destruction of evidence, and to prevent an offender's escape. While these categorical exceptions to the warrant requirement generally would allow for straightforward guidance to law enforcement and lower courts, the Supreme Court has come to apply this exception for exigent circumstances on a case-by-case basis, which has indubitably led to misunderstandings and misapplications of law. One such misunderstanding came from the application of the hot pursuit doctrine outlined by the Supreme Court in the 1976 case of the United States versus Santana, specifically as it was applied by California courts and many other jurisdictions as creating a categorical rule permitting the warrantless entry into a home where an officer is in hot pursuit of any suspect. While acknowledging the warrantless entry of a home to apprehend a fleeing felon was reasonable, the Santana court stated that whether the same approach would be applied to misdemeanors would be decided in a future case. That prediction was brought to fruition some 45 years later in the 2021 case of Lange versus California. In the Lange case, the court took up the question of whether there is, or should be, a categorical rule permitting law enforcement to pursue any offender, particularly misdemeanants, into their own homes. The court was faced with upholding, expounding, or overturning its previous opinion from Santana, without considering whether Santana represented a categorical rule for felony offenders. The court turned its attention specifically to fleeing misdemeanor offenders as the question was presented by the facts of Lange. The Lange case concerned a California Highway Patrol officer attempting a traffic stop upon a vehicle operated by Arthur Lange, which had been playing loud music and honking the horn repeatedly. Mr. Lange, who was around 100 feet from his home, did not yield to the officer's activation of emergency equipment, but proceeded to his residence and into his garage, which for the purposes of the court was into his home. The officer followed him into the garage, observed signs of alcohol impairment, and subsequently arrested Lange for the misdemeanor traffic charge of driving under the influence with a blood test indicating Lange's blood alcohol level of being more than 3 times over the legal limit. Armed with those facts, the court began its evaluation. The court set out by identifying the constitutional interest at the heart of the case, which was the sanctity of the home. In identifying the paramount interest in protecting the home, the court allowed that in past cases a warrantless entry of a home has, at times, been found to be reasonable, particularly for serious offenses, as was true in the Santana case. Considering the gamut of offenses which are categorized as misdemeanors, the fact that some offenses are more serious than others was not lost on the court. The court acknowledged that some misdemeanors involve acts of violence, contrasting these offenses with a number of far less dangerous misdemeanors. In rejecting a rule which would always allow the warrantless entry of police into a home of a misdemeanor based solely on their flight, the court allowed that there would still be, in many cases, if not in most, instances where that entry might be reasonable. The Lange court, at least for misdemeanors, adopted a case-by-case approach which, in light of the totality of the circumstances, would consider whether the facts presented might amount to a law enforcement emergency, thus making the entry reasonable, while holding that the need to pursue a misdemeanor offender alone might not constitute an emergency in every instance. The court announced that a law enforcement officer need not wait to act where there is a threat of imminent harm to the officer or a third party, the imminent destruction of evidence, or escape from a home. Having found that the lower court was incorrect in finding a categorical rule for the pursuit of misdemeanors, the Supreme Court remanded the case back down for further proceedings consistent with its holding. My name is Sam Lockridge, and this has been Fletsy Talks.